Thank you very much, Gemma. Great to have so many of you on the webinar this morning. Thanks for sparing the time. Thanks to Gemma for setting it up, and in advance to Geraldine for what I know will be another excellent session of vital importance to anybody in the contracting world. This is as we head towards the summer, we have a few more webinars planned, and we are looking in due course to have a sort of blended approach, some which will be face-to-face, some which will be online. But if there are topics that you'd like us to cover, do let us know. Now's the time to do it. We can start putting together our autumn and winter program. So have a think about anything you'd like us to put into that program, and we'll do our best to do that. If you don't get the copy of the weekly newsletter, which has details of all of the events, let me know, and I can add you to the list. I'd be very happy to send it out to you. Now, as an ex-journalist, I think I know a bit about communications, but in 30 seconds' time, I'm about to find out how little I do know. It's a topic which I was surprised to see in the programme, but I'm really looking forward to it. I hope you are too. So, without further ado, over to you, Geraldine.
Brilliant. Thank you, Guy. And thank you very much, Gemma, as well, for sorting out all of the things that I wanted the delegates to know in advance, which is great. So yes, I'd like to start by welcoming everyone here to this session on communications. As has already been said, my name is Geraldine Fleming and I work for Driver Tret. As normal, the first few slides in the pack are a little bit of information about me and the company I work for. So yes, Driver Tret is the name of the company. We work across multiple sectors. So you can see there some pretty pictures on process and industrial, marine and offshore, and infrastructure. We essentially are a global construction consultancy, which is established in 1978. We're a market leader in expert witness, planning, commercial, technical, importantly for me, dispute avoidance. And that really is the point of today's session. It's to show to you the importance of communications and how they can actually help you avoid disputes. We are stock market listed with over 300 staff working worldwide. Various offices throughout the UK. I normally work out of our Hooton, Cheshire office, and our head office is in Hadslingden in Lancashire. Lots of information in terms of what the different parts of the businesses do. On the left-hand side, we have driver project services, and essentially that's a staff augmentation part of the business. So we can provide quantity surveyors, planners, project managers onto your live projects. I work for Driver Tret, and yes, it's all about dispute avoidance and dispute resolution. But definitely a chunk of my work, of course, is training. Not just these 1 hour sessions that I do fairly regularly for Seeker, but also on an in-house basis for a half day or full day for companies such as yourself. We also have planners and delay analysts working for the business, as well as legally qualified quantity surveyors who can look at the commercial side as well. Dialis is our expert witness division, and we have experts in delay, quantum and technical issues as well. As well as that, we have experienced adjudicators, arbitrators and mediators working in the business. Huge range of areas that we can work and assist your business on. I've read lots of these out before, but I will just emphasize firstly, doing contract reviews before you sign the contract, a hugely important part, and particularly when it comes to this issue of communications. In my view, too many people sign up to contracts that actually they then can't actually fulfill the requirements on the communication side. The other one I've highlighted here is on insolvency. We are just finding an increase in our workload in working for particularly main contractors who are finding that subcontractors have become insolvent, and making sure that they keep their paperwork in good order to avoid an adjudication from an insolvency practitioner at a later date. We do have our regular digest that comes out twice a year. You can get it from the website, from the marketing department, or you can actually take a picture of the QR code and it will take you right to the magazine. A little bit about me, and certainly one of the disadvantages of doing this session via the webinar is obviously you're all very well trained and have your microphones off, so I don't get to hear the boos when I announce that, yes, I am a quantity surveyor, that I'm chartered, I'm ex-BAL for BT, so normally I've got 3 boos by saying all of that. I did go on and do my law degree and solicitor's exams. Made a conscious decision not to move into the pure legal side because I really enjoy basically working with construction companies in improving their procedures and making sure that they get the best possible outcomes on the different projects that they're working on. What are we going to cover today? Well, in brief, we're going to do a little bit on an introduction, a true story on a job that I worked on last year and looking at some terms and conditions there. We're going to look at some case law and the importance of understanding what condition precedent clauses are. A chunk obviously on NEC contracts, because I know for civil engineering that would be the most common contract that you come across. But I am also going to go through the JCT as well, because when you are working on bespoke contracts, actually they do look quite like JCT contracts as well. Looking at letter writing and emails and some rules and regulations as far as I'm concerned, and then a quick summary at the end. So, an introduction then, and it's pretty obvious what we will start off with here. What are the methods of communication that we use? Well, of course, when we are able to work on site and have proper meetings, then there are lots and lots of verbal and oral communications. And even passing things to each other by hand is still very common. And I'm thinking there of a progress report that's handed over at the start of a site meeting. For those of you who are my age or older, obviously you will remember things like faxes and telexes. Unusual to see those actually physically used, but I am still seeing contracts that do specifically refer to service of documents by fax, and that's something to be aware of. Post is obviously a little bit more difficult, particularly with COVID over the past year or so. And of course, there is normal post as well as recorded or special delivery to be aware of. Courier delivery is quite common, particularly when you're delivering files. But more and more, we are moving into the electronic age. Emails, I'm sure that all of us are still sending lots and lots of emails to each other. Texts are common. Communications via LinkedIn is something that I would do fairly regularly, but obviously not on a contractual basis. I have had meetings with clients and the other side on WhatsApp when we haven't managed to get Team or Zoom to work. And you can see the horror in my little graphic there, the thought of using something like Snapchat. What you must be aware of is you need to check the communication clauses in your contract. And I also want you to think long term. How are these communications, all of the different types that I've mentioned here, how are they then captured within your organization and held and retained for 6 years, 12 years, or even longer? Now, I am certainly aware of a very, very long list of excuses why the correct notices or the correct communications aren't sent. So, just in case anyone hasn't got a full list, this would be my list that I've heard in the past. Things like, we need to get the job done. We haven't got time to start letter writing. Okay, I'm not having that. Part of getting the job done is keeping the right communications. We don't want to upset the client. Now, you might be a subcontractor not wanting to upset the main contractor, or a main contractor not wanting to upset the client. I would really like to shout this, but obviously I don't want to deafen anyone. It's very likely that they have chosen the contract and they have imposed these terms on you, including the communications clauses. So if they've put these clauses into the contract, all you are doing is administering their contract. And again, this true story that I will go through in a few minutes, The senior QS on the other side actually said to me, "Look, you're winding everyone up by sending these letters." To which I said back, "Well, let's change the contract then. I'm very happy to amend the contract and take some of these clauses out." And he said, "Well, we're not going to do that, are we?" And I said, "Well, we're in a no win situation here. We're going to have to keep sending these letters to you." I appreciate you don't want to be seen as commercially aggressive, but neither should you want to be seen as naive or daft by not sending the right communications. I appreciate that. Does it affect the long term prospects for future work? Potentially. But actually, if there is no business to actually take this future work because you've not kept the notices on your current job, well, that's not of great importance at the moment. I don't know how many of you have listened to the radio this morning and the CEO of John Lewis bemoaning the fact that people who join John Lewis can't write letters and haven't got basic maths skills. Yes, I do think we have lost the ability to write good letters. And too often we want to get the fact of sending a communication to someone else off our desk as soon as possible. And we do need to take more time and more trouble to get our message across. And that's really what we're going to concentrate on at the end of today. The one that bugs me out of all of them, though, would be that an organization or its representatives haven't read the contract. And that for me is close to a mortal sin, I would say. You have got to read the contract that you've signed up to in order to make sure that your communications are correct and valid. So for me, the aim of today is definitely to frighten you all into writing the correct contractual correspondence at the right time. And part of the way I'm going to frighten you is through this true story. And it's a recent project that I was involved in. It was a main contractor subcontractor dispute, and it wasn't a big job at all. The subcontract value was £232,300. You might just be able to make out the small print depending on the size of your screens. Nothing too contentious here. It said the commencement date was the 1st of November 2019 with a 29-day period for completion in calendar days and giving a date for completion of the 30th of November 2019. Well, let's just ignore the issue of adding up because obviously between the 1st and the 30th, that would be 30 days and they've for some reason gone for 29 days. That wasn't important in the overall story. We got involved on this particular case in May 2020. At this point, no work had been completed on site and no materials had even been ordered by the subcontractor. There was going to be an approximate 12-week lead in. So if I take the 30th of November 2019, the original completion date, we got involved in May 2020 and I add the 12-week lead in, takes us to roughly the end of August 2020. That's a 9-month delay or a 40-week delay. And an initial review of the subcontract revealed the following. Liquidated damages. They were subcontract liquidated damages, not main contract, subcontract liquidated damages. So if the subcontractor completed late, the rate for liquidated damages was £5,807.50 per week. Roughly, if I say a 40-week delay times 5,800 gives us a liability at that point of 232,000. I'll just flick back to the previous slide. The subcontract value was 232,300 quid. So at the time we got involved, there was a huge liability there. We then looked at the notification clauses in the contract. And I will say these are horrible. It stated, if the progress of the subcontract works or any section is being or is likely to be delayed, the subcontractor shall, within 14 calendar days of the delay first occurring, give a notice to the main contractor identifying the delaying events and the date the delay first occurred. 5.2. In respect of each and every notice by the subcontractor, in accordance with 5.1, the subcontractor shall, as soon as practicable thereafter, and in any event, not later than 21 calendar days after the date of such notice, give particulars of the delay by way of a further notice to the main contractor. And the clause then went on to say what kind of things were required, and it included an updated programme. The killer blow came at clause 5.4. Provided always that it shall be a condition precedent to the contractor's entitlement to be granted an extension of time award that the subcontractor has given the notices needed by clause 5.1 and 5.2. No surprise at all, not a single notice had been issued by the subcontractor at the point that we got involved. And the most annoying thing for me was the subcontractor had very good entitlements for a huge part of that delay period because, quite simply, the main contractor was well behind the programme themselves. The subcontractor couldn't get onto site to do those works, regardless of the fact that the materials hadn't been ordered. In this particular case, we did manage to negotiate an extension of time on behalf of the subcontractor. I'm going to describe it as probably one of the miracles of my career. It did involve lots of sleepless nights, mainly for the firm, but a couple for me, and at the end, a very happy client. But importantly, the situation was entirely avoidable. Either they shouldn't have signed up to these types of clauses, or knowing that they'd signed up to them, they should simply have issued those notices as the client required. And this company is not alone in this situation at all. If we move and look at some case law, my probable favourite case on this is one that if you've attended any of my sessions on payments, then I will have mentioned this particular case. Kersfield Developments and Bray and Slaughter back in 2017. A simple case and really all about smash and grab adjudications. It was a JCT Design and Build 2011 contract with a contract sum of £5 million. And the project involved the refurbishment and conversion of a manor house and stable block and the building of some detached houses. Bray, in this particular case, with a subcontractor, Kersfield with a developer. The subcontractor here issued an interim application, payment number 19, on the 5th of August for £1.2 million. That was the interim value. Kersfield sent a payment notice and a pay less notice. It was sent at 10 to 10 on a Friday night. Unfortunately, the payment notice was too late. In theory, the pay less notice should have been on time. However, the developer had changed the JCT contract and said that the contract, that the notice served takes effect as having been given or served if sent by hand or email, if it was served by 4 o'clock on a business day. Otherwise, it takes effect on the next business day. Now, because the email was sent at 10 to 10 on a Friday night, Friday the 12th of August, it didn't take effect until Monday the 15th of August, and therefore the pay less notice was out of time. Goes to adjudication, and Bray were entitled to the full amount of their money. So in this particular case, the alterations to the contract actually were in favour of the subcontractor, and you can imagine that the developer was not best pleased at having included this particular contract amendment, which essentially shot themselves in their own foot. Another case going back a while ago, 2006, but it is a Northwest case. This was all about the determination of a contract. We would now call it termination. The contract conditions of contract required a warning notice and then 14 days later a notice of determination. And the contract required notices to be in writing and given by actual delivery or special or recorded delivery. Construction Partnership gave a warning letter by fax on the 23rd of December 2005, timed at 7:45 in the morning, and it was also sent by post. No payment was received, which was the breach that was being looked at, so a notice of determination was sent on the 17th of January 2006. In this particular case, the developer, who was receiving this correspondence from the construction company, claimed that they didn't see the fax until after the Christmas break, and therefore the notice of determination was premature. The 14-day period hadn't been complied with. It was held in this case that the warning notice issued by fax in this case was valid. It was actual delivery. Leaks offices didn't shut until noon on the 23rd of December, and in this case, the determination was valid. But again, the parties should never have had to go to litigation on this particular issue. We want to make life easy and make sure that the communication protocol that's agreed and is in the contract is simple to operate and understand in every single case. Now, it's important here to understand what the phrase condition precedent means, and indeed what a condition precedent clause is, because it is so important to understand this bit to then be able to interpret the contract conditions properly. So, a condition precedent clause is one in a contract that provides that certain obligations under the contract will only come into force if and when specified conditions are met. There is no special form or words required to create a condition precedent. If I was writing a clause like this from scratch, then I would, again, for ease of understanding, I would include the phrase condition precedent. It is a condition precedent that, or words along those lines, but it isn't needed. If you see the phrase subject to, that would suggest that the clause is a condition precedent. And certainly a notice provision in a contract should be construed as a condition precedent if it states the precise time within which the notice is to be served. So you saw on my example before, within 14 days, within 21 days, and also that it makes plain by express language that unless the notice is served within that time, that the party making the claim will lose its rights. So we saw again in that earlier example, it used the phrase condition precedent, and then it referred to complying with clauses 5.1 and 5.2. So I am expecting to see a deadline for fulfillment, a date or a time period. And if you fail to give those notices, that the relief is denied, that you're not entitled to an extension of time, that you're not entitled to loss and expense, you're not entitled to additional monies. Also, how you can fulfill the condition. Is it notice, by post, by fax, by email? And what does that notice actually have to say? Keating on construction contracts, one of the big fat textbooks in our offices, says this: many contracts provide that the contractor's entitlement to an extension of time is dependent upon, amongst other things, the service of a notice within a stipulated time of an event causing delay. Courts are normally reluctant to construe the requirements as to the form and content of the notice required under such clauses too strictly, and are unlikely to treat them as condition precedent to the making of a claim, as opposed to procedural requirements, absent clear language to this effect. So, in other words, for a clause to be a condition precedent clause, it must be very clear. I do like this quote from a non-construction case. This was all about an investment that was being made, but it is often quoted. Lord Hoffman in the House of Lords said, "If the clause had said that the notice had to be on blue paper, it would have been no good serving a notice on pink paper." So that's how prescriptive the parties can be as to how they speak to each other. Another case, actually a famous case, Multiplex and Honeywell, which involved Wembley Stadium. Justice Jackson said, "Contractual terms requiring a contractor to give a prompt notice of delay serve a valuable purpose. Such notice enables matters to be investigated whilst they are still current. Furthermore, such notice sometimes gives the employer the opportunity to withdraw instructions when the financial consequences become apparent." So, in terms of what we've looked at so far, yes, condition precedent clauses are common in construction contracts. They do need to use clear words. You do need to follow them. And the courts generally will uphold them if the wording is clear. Another case back in 2010, W.W. Gear and McGee. Now, McGee here are the employer and W.W. Gear were the contractor. And this was all about groundworks for a hotel in Westminster in London. Contract sum here is 1.8 million, and it was a JCT contract with some amendments. I've included the full clause in front of you. Now, this has been changed from the standard JCT wording, and I've highlighted some bits. This is all about claiming loss and expense. So, in other words, prolongation costs for delays that occurred on site. It says that the trade contractor was entitled to claim loss and expense or prolongation costs, provided always. Now, that's very like subject to, and it suggests condition precedent. But in this case, anyway, the clause had been amended to say the application to be made within 2 months. And again, it says it's a condition precedent, including complying with the notice within the 2-month period. W.W. Gear were claiming 1.5 million, but unfortunately, they failed to submit a fully documented and costed claim within the 2-month time period. And the court found in this case that the contractor was not entitled to any of its claim because it hadn't complied with the condition precedent clause. 1.5 million down the drain, all because they hadn't complied with the contract clauses. A little bit more up to date, a job in Gibraltar, Abrascon and the government of Gibraltar was all about a FIDIC Yellow Book 1999 contract. Clause 1.3 talked about notices being given by hand or mail or by courier to the Madrid office. Notices here were actually delivered to Abrascon's site office. And in this particular case, it was held that the notice of termination was valid. So this is Abrascon writing to, Gibraltar writing to the Abrascon to terminate. And it was held it was valid because in this case, clause 1.3 wasn't a condition precedent clause. The courts decided on balance that it was sufficient that the notice was given to someone of a sufficient authority. In this case, the responsible offices of the recipient. Moving along a bit, 2015 in this particular case, again, this related to entitlements in relation to actions after a force majeure incident. The courts here decided it wasn't a condition precedent. As you'll see at the bottom, it did talk about 20 working days, but it didn't go on and say, and if you don't comply, you lose your rights. So this wasn't a condition precedent. The most up-to-date case I could find on this was 2017, Glen Water and Northern Ireland Water. And again, the result of this case was that condition precedents will be enforced when they are clear. The court here said, I do have some sympathy for the plaintiff's position because the failure to notify prevents a claim being made. It might seem harsh when commercial parties anticipated that a claim might come to pass. However, I have to decide the case within the parameters of commercial and contract law. The contractual terms are clear, and commercial certainty is an overarching consideration. The evidence as to the commercial context and surrounding circumstances has not remedied the defect in the letter. It seems to me likely that the notification requirement was overlooked amid a mass of claims and in the midst of the ongoing process of discussions. So quite simply, again, the contractor had a valid claim but failed to give the relevant notice. So if we look at notice requirements, firstly in relation to NEC contracts, and NEC is strict. If we first of all look at NEC 3, I've quoted here first of all clauses 13.1 and 13.2. First of all, you'll note 13.1 that all of the communications between the parties must be in a form which can be read, copied, and recorded. In other words, no verbal instructions, no verbal communications. Looking at 13.2, that states a communication has effect when it is received at the last address notified by the recipient for receiving communications, or if none is notified, at the address of the recipient in the contract data. Now, of course, I'm sure the vast majority of you know that if you looked at NEC3 and the contract data, it states the names and addresses of the parties. It doesn't have a box for email addresses. And it's only on very few occasions have I seen that the contract data under NEC3 has been amended to include emails. So in other words, emails aren't valid unless the parties notify each other post-contract that emails could be used. And that certainly is something that I would want everyone on the session today to look at in relation to their live projects. Do you have an agreement either in the contract itself or post-contract that you can communicate by email? When I look at NEC4, Clause 13.1 has been simplified, which is great. So it doesn't give that big long list of the types of communications. It just says communications generally. Still no verbal instructions. And again, that gets a big thumbs up from me. The contract data here has been amended. I do worry whether it's going to be completed or not, though. I've given you here the example of the client. You would give the name, their address for communications, and you've also now got a box for electronic communications, which of course you could put in email addresses. 13.2 has also been amended, and this is positive. Essentially now NEC4 is on the information superhighway and is much more modern. 13.2 states, if the scope specifies the use of a communication system, a communication has effect when it is communicated through the communication system specified in the scope. Now, that does sound like something out of a Monty Python sketch. But essentially, the scope is the new phrase, of course, for the works information. And I would be expecting a communications protocol in that works information or scope. So, in other words, any communications that you're going to have between the parties should then be referenced via the works information by some kind of protocol. It goes on to say if the scope doesn't specify a communication system, a communication has effect, again, as we saw before, at the last address notified by the recipient for receiving communications, or if none is notified, at the address of the recipient in the contract data. Now, this communication system, I think, is probably referring to some kind of cloud based document management system. In theory, this should be a good thing because all of the communications are in the one place. However, wearing my very negative hat, I have many concerns on document management systems, particularly concerning trust. Do I trust the other party not to fiddle with the background of the system and lose things that I have sent? How am I, as an organization, going to retain all of the paperwork if the system belongs to another company? How are we going to do that on a long term basis? Emails, I think we're all happy that we can keep those for the 6 or 12-year period. But worries certainly are with me in relation to issues such as insolvency. Is anyone from Carillion paying the license fees for the document management system when they became insolvent, I think 3, 4, maybe even longer ago than that? And my suspicion is that they aren't. So, how can you then prove what you did or you didn't do on a project when you can't get hold of, I shouldn't really be saying the paperwork, but the documentary evidence to say that emails were issued or instructions were given via this communication system? And that needs further consideration. Another clause that you need to be aware of in NEC 4 and, of course, in NEC 3 is this one. The additional words underlined and in bold are the new words in NEC 4. So, a notification or certificate which this contract requires is communicated separately from other communications. So, essentially, each of the examples that I've listed out here, encountering physical conditions, late access to an area where a third party contractor is late, or late provision of free issue materials, all of those would have to be issued separately. You couldn't bundle them up together and put them in a weekly progress report or in a letter. Of course, the main condition precedent clause that you will come across in NEC 3 and in NEC 4 is clause 61.3, and I've quoted the full clause here. 61.3 says the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event if the contractor believes the event is a CE and the project manager has not notified the event to the contractor. If the contractor does not notify the compensation event within 8 weeks of becoming aware of the event, he is not entitled to a change in the prices, the completion date, or a key date unless the event arises from the project manager or the supervisor giving an instruction, issuing a certificate, changing an earlier decision, or correcting an assumption. So we have this 8-week period, but only in limited circumstances where you, the contractor, have to give those notices. However, watch out for amendments. Let's imagine that this was your clause. If the contractor doesn't notify the compensation event within 2 weeks, and all the rest of the clause after the unless has been deleted, this would mean that the contractor must notify everything. And this is a great example of a condition precedent clause that doesn't use the phrase condition precedent. If you didn't give notice, even here, if it's of an instruction that you're given within 2 weeks of a change to the prices, the completion date or a key date, you lose your rights. And of course, if you're not entitled to a change in the dates, you might also be exposed to liquidated damages. And of course, you're also not going to get your prolongation costs. Whenever I'm doing a review on NEC3 or NEC4 contracts, this would be the first clause I would look at. And that will give me almost, it's like taking the temperature of how severe or strict the particular contract that I'm going to review is. Okay, I did say that I was going to talk about JCT contracts. Obviously, you're more than entitled to get a copy of the notes at the end of the session anyway. I'm not going to go through and read every single one of the slides in this section. JCT has a longer communications clause. There is still doubt, however, as to whether emails are valid. Again, JCT is expecting under 172 for an agreement to be made. Certain communications under JCT, as you'll see from 174, the first clause here, must be delivered by hand or sent for by recorded, signed for, or special delivery. And that includes termination notices under a JCT contract. If you gave your termination notice in any other way, then it wouldn't be a valid communication. There is doubt as to whether JCT, in relation to claiming loss and expense, as to whether it is or it isn't a condition precedent clause. And here we are sat in 2021, some 5 years after the launch of the JCT 2016 contracts, and we're not sure whether this is or isn't a condition precedent. It doesn't use the phrase condition precedent, but you can see from the underlining that I've done there in pink, it says subject to compliance with 419.2 and 420. Subject to is a good indication that it is a condition precedent clause. And when we look at clause 420, it clearly says that the contractor must notify the employer as soon as the likely effect of a relevant matter means that loss and expense is going to be incurred. Now, if you go right down to the bottom of this particular slide, one of the members of the drafting committee said, JCT has not adopted the approach of some bespoke amendments whereby notification by the contractor in accordance with a time limit is a condition precedent to entitlement to loss and expense, which means in principle that non-compliance avoids the claim. Here, we haven't got a time period. It just says that the contractor has got to notify the employer as soon as. Now, I don't want any of my clients, contractors, subcontractors, to be a test case on this particular issue. So my view is if you see this type of clause, if it's at tender stage, you get clarity on it. And you either agree that it is or it isn't a condition precedent clause. You don't leave it in this grey area. If we are post contract, then you should treat it as a condition precedent clause. And I would actually put in a mental time period here of 48 hours to give the notice, because I don't want you to lose your rights to claim this loss and expense. The last few sections I want to go through are some letter writing tips, and they sound flipping obvious, but it's amazing how often that I get a bundle of correspondence, including some letters, and something obvious like the date on the letter is missing. I'd say probably 1 in 50 letters that I review, actually there's a date missed off the letter. So, obvious things: your name and address, and their name and address, and a reference, your reference and their reference if possible. The date including the month in full. And of course, when you're in January, it is so easy to get the year wrong. So an extra check on January is worthwhile. Say on the letter how you are sending it. If it's by post only or email only, and certainly if you're sending it by email, list out the email addresses. I do want you to say the project name, and I also want to see a subject line. So the subject line could be current position, it could be notice of termination. State very clearly if you are enclosing documents. And of course, if you're writing an email, you'd use the word attach. I think a very good piece of advice is that the first paragraph of your letter, you are going to say what you're going to say in the letter. Paragraph 2 is you actually deliver the message and you say it. And the third paragraph is a conclusion where you say what you have said. Now, that sounds like an awful lot of repetition, but that way, you as the writer are very focused on what you should be saying. I definitely am not impressed by big, long, complicated words that I then have to go and look up in a dictionary, nor am I impressed when I've got to go and get a ruler and read words out loud because someone has forgotten to put in commas and full stops. So, short sentences and easy to understand words. You want to get your message across. I am in great favour in a letter, particularly when a letter is over a page long, of using paragraph headings. It helps with you structuring your letter, and it also helps the reader read the letter. And an obvious thing, proof reading. So you write your letter, print it out, and then you reread it. Or think about asking someone else to check it over. If I'm writing a notice of termination, I will always get somebody else within our organisation to check it through for me because that type of communication is so important. Other tips that I've picked up on include this. What type of letter are you going to write? Is it formal, semi formal, or informal? Um, Potentially, you could say a quotation could fall into all three. The tone of your letter is going to be based on how you've answered that previous question. Think about how you are going to open and close the letter. If it's formal, are you going to go for dear sir or madam? Then you would end it, of course, yours faithfully. If you're going for semi formal, you're going to address it to the individual, and then it would be yours sincerely. More informally, dear John, dear Anita, in my example. And then, of course, it would be a best regards. Thinking of the types of letters that you are going to write, I would imagine that they would almost all fall into the formal category because semi-formal or informal would be more likely to be an email. So certainly opening the letter with a formal sentence, straight to business and indicating the reason you are writing. So, dear sir or madam, we are writing in connection with. Okay, and that's a really good opening sentence. Or we hereby notify you, and then whatever that is. Quickly identify the main purpose of the letter. Are you writing a notice, in which case, of course, you've got to use the word notify? Are you asking for information, inviting someone, complaining, or thanking someone? Spelling. The common ones, and yes, I will also make these mistakes as well as you guys. There, and of course, there's another there as well. Your and your, spelling receive wrong, and spelling business. Making sure your spell checker is on in Word, Excel, and in Outlook. That's again a very common issue. Thinking about the grammar. It pains me to say this, but I think it was Michael Gove who informed, I think it was the Department of Education at the time, that you must not use contractions in any communications with him. So none of this can't, don't, or won't. You have to use the words in full. Cannot, do not, will not. And actually, yeah, I agree with him on that, particularly in formal letters. Capitalitis is definitely a disease that affects people in the construction industry, and that is the overuse of capitals in communications. You need to be able to justify why any word has got a capital. I will accept the name of a town, and I will accept the start of a sentence. I will also, I have sympathy with when you are matching the communications in a contract. Other than that, I struggle with the amount of capitals that some people use. Always use factual language and never emotional language. There are plenty of court cases, particularly, I'll say, on the use of Twitter, where emotive language is pulled up by the judge and sanctions are put on one of the parties. Another one, setting out. You need to make the letter look attractive, or as I've said here, balanced on the page. Space it out and make it easy for people to read. Organize your thoughts. Be clear, direct, and use words people will understand. Make the point easy to find in the subject and within the body of the letter. Checking and proofreading again is important. As part of your checking procedure, is the purpose clear? And will the reader know what to do, how to respond, or what you are asking? Emails. There really should not be any difference between letters and emails in terms of the formality. But yes, I will hold my hand up and say I do start emails with the word hi, particularly where someone has written to me with the word hi, because otherwise I think you do look maybe a little bit difficult. Making sure you're sending the email to the correct person is an obvious one, and Outlook is very helpful because as soon as you start to type the name Amy or John, it will suggest the names to you. That needs an extra check. Have your spell checked enabled in the settings. One topic per email if possible. Please do not have emails going on and on and on about different subject areas. An appropriate subject line is really important because quite often we reply to previous correspondence and reply and reply and reply, and the subject line becomes out of date. And then it's very hard to track your emails at a later date. Short paragraphs, easy to understand, again, getting your point across. Being polite is again important. Taking care with who you copy in and not copying in irrelevant people. I actually think this is a good tip, although sometimes I do break this one myself. Your email should not be more than one screen in length because the likelihood of someone reading it all is reduced, or you're forcing someone then to print it off. As far as possible, a positive tone. Not writing in capitals because that's seen as shouting. Again, even in emails, italics, bold, and underlining and headings, I think, are a good idea. Having attachments is good, but don't have too many attachments. And you can see a lovely spell check there, just to remind me to tell you again about spell checking. In summary, let's go back to basics here. Don't sign any contract without understanding the terms and conditions, including relating to communications. And do consider the effect of these cloud-based communications, training your guys to make sure they use them properly, retaining information and proving that correspondence was sent. Make a list in each contract of condition precedent clauses and review it regularly. Remember that communications are not just for when you are live on site. They are also important in the off-site and design period. And that's where my client in my true story went wrong. Always send the letters and communications that are required. And do not believe this kind of nonsense. We'll sort you out at the end of the job, mate. Or you don't need to bother with these contractual letters, or you won't get any more work from us if you carry on in this way. Your job is to protect your business, and generally those clauses have been imposed by them. So all you're doing is following their instructions. With 3 minutes to spare, Gemma, we get to the question time slot. And yet again, I am hoping for easy ones or none at all, if possible. I think we haven't got any, Gemma, at all here. So I will quickly remind people of my contact details just in case anybody wants to email me with any particular communications themselves, obviously appropriately spell checked with an appropriate subject line. But apart from that, Gemma, I think I'm done.
I think you may be done, Geraldine. Record time, 2 minutes to spare.
Excellent.
As Geraldine mentions, all her contact details are available through there. So if you do want to drop Geraldine a line or send anything via us at Seeker, please feel free to do so. Thank you very much, Geraldine. Very, very interesting, as always, and really useful, I think, also not just in a contractual and commercial way, as Guy's put in there, I think very relevant across the industry as well. So I'll pass you on to Guy just to wrap up, but thank you very much, everyone. As I said before, you should get a copy of your certification and things sent through afterwards and a copy of the slides. So thank you very much.
Thank you, Gemma.
Well, thanks, Jem, for setting it up, and Geraldine for another excellent seminar. Some really brilliant advice there. It's something I wish I'd been to about 20 years ago. I might have learned a bit more in my attempt to do public relations and journalism. So thank you very much. Thanks to everyone on the webinar today. Hope you found it useful, and do let us know if there are topics that you'd like us to cover in our autumn program. And if you have any other issues that you want to raise with Seeker, do drop us a line. So thanks very much, and see you again soon. Bye-bye.